That's just something. All right, it's 3:30, folks. Okay, it's 3:30, so I think that it's time to begin this hearing today, and I'm going to call to order the meeting of the Calhoun County Election Commission to conduct a clarity and factual review hearing. The Calhoun County Election Commission is in session today to consider the matter of the clarity and factual nature regarding a recall petition filed with the county clerk, and the filing date is March 31st, 2023, against the Marshall Township trustee Robert Lyng. Notice of the meeting has been properly given to the sponsor, the officer being recalled, and has been properly posted for public interest. And the proceedings will be recorded and minutes will be taken. I'm going to ask that everyone please stand and join me in reciting the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Excuse me. I have that springtime allergy thing going on here. So I'm Mike Jacquinette. I'm the probate judge for Calhoun County, and by statute, the probate judge is the chair of the County Election Commission. I wasn't able to be here at the last clarity hearing that was held, so I think the prosecutor, if I'm not mistaken, substituted for me. I'd like to introduce the other members of the Election Commission. To my immediate left is Kimberly Hinckley, who is the Calhoun County Clerk and Register of Deeds, and just beyond her is Brian Wentzauer, who is the Calhoun County Treasurer. And I'm going to ask at this time that we have a motion to approve the agenda for today.
I'd like to make a motion that we approve the agenda as submitted.
I'll second that.
All right, is there any discussion in that regard?
No.
All right, hearing none, all in favor of the agenda being approved, say aye.
Aye.
All right, the agenda for today is approved, and I think that there were copies of it I saw out there in front of the meeting room. So the role of the County Election Commission is defined by statute and is stated in Michigan election law, MCL 168.952, subparagraph 3, quote, "The Board of County Election Commissioners shall meet and shall determine whether each reason for the recall stated in the petition is factual and of sufficient clarity to enable the officer whose recall is sought and the electors to identify the course of conduct that is the basis for the recall. If any reason for the recall is not factual or of sufficient clarity, the entire recall petition shall be rejected," close quote. Now, this hearing is not for the purpose of debating the merits of the allegations in the petition. The Commission does not have the authority to rule on the reasons for recall, as only the clarity and factual nature of the recall language is subject to the Commission's review. There's a script here I'm reading, but I'm going to step away from that for a second just to say that we don't have the authority to swear in witnesses, to receive exhibits and that sort of thing, as you would in a court. So this is a tribunal, if you will, and so it simply is confined to looking at the language that's contained on the petition and making the determinations based on that language itself. Because I stepped away from the script here, I forgot whether I read this paragraph, so I'm going to read it again if I haven't already. This hearing is not for the purpose of debating the merits of the allegations. The Commission does not have the authority to rule on the reasons for recall, as only the clarity and factual nature of the recall language is subject to the Commission's review. I did read that, so I read it again. The truthfulness of the allegations is not for the Election Commission to assess, but rather is something that the office holder can respond to as part of the political process if a recall election is held. Therefore, the commission will not accept presentation of evidence or sworn testimony at this clarity hearing. And again, even if we wanted to do so, we don't have the authority to do so. So the next matter is the consideration of the recall language. This has been filed by Glenn Kowalske against Marshall Township trustee Robert Lyng. And again, the sponsor of the petition is Glenn Kowalske, who is identified as a resident, registered voter of Marshall Township. The electoral district represented by the officer is Mr. Kowalske here? Yes. All right, Mr. Kowalske has filed language. And I should ask also, is Mr. Lyng here? Yes. All right, Mr. Lyng's here as well. Mr. Kowalske has filed language in a recall petition that reads as follows. Quote, Robert Lyng was on the board of directors of the Marshall Area Economic Development Alliance, while also serving as a Marshall Township Planning Commissioner and trustee. On January 26th and February 20th, 2023, he voted yes, approving the Public Act 425 land transfers to the City of Marshall as trustee of Marshall Township, close quote. So, Mr. Kowalske, if you could come up to the podium there, please. And, sir, first off, if you state your full name for the record.
Glenn Kowalske.
All right. And, sir, are the allegations stated in the recall petition based upon the officer's conduct during his current term of office?
That's correct.
All right. Now, you do have the right, if you wish, you or your representative can comment on the recall petition language if you wish to do so. We'd limit that to 5 minutes. Do you wish to do so?
Yes.
All right, go ahead.
The petition language was chosen to be simple and factual for the benefit of the petition signer. The petition language is one statement consisting of 2 sentences. Mr. Lyng is a director on the board of Maeda representing Marshall Township as evidenced by the current Maeda website information. Further, Mr. Lyng has stated this publicly at recent Township Board public meetings January 16th and March 20th, further stating that he signed an NDA with Maeda. Mr. Lyng is on the Marshall Township Planning Commission, currently vice chair as evidenced by the Township webpage, as well as October 4th, 2022 Planning Commission meeting minutes. Mr. Lyng is a trustee of the Marshall Township Board as evidenced on the Marshall Township webpage and the January 26, 2023 meeting minutes. His unopposed election results are also on the 2020 Calhoun County election results webpage. The position as trustee on the Marshall Township Board is clearly the only one that has the authority to vote on PA 425 transfers. The petition clearly states that Bob Lyng, a Marshall Township trustee, while also serving on the Marshall Township Planning Commission and Marshall Area Economic Development Alliance 501c3 corporation. The 2 sentences are of course read together and would appear to a reasonable person that the reason for the recall is the fact that Trustee Lyng voted yes with respect to land transfers on January 26 and February 2023, and that such a vote was improper or in conflict of interest because at the same time Trustee Lyng was serving on the board of directors of the Marshall Area Economic Development Alliance and as a Marshall Township Planning Commissioner. The petition language would appear to a reasonable person to be a course of conduct that is the basis for recall. The term PA 425 transfer and Public Act 425 land transfer is used extensively and clearly to describe the Michigan Public Act 425 statute process as evidenced by the MEDC flyer explaining the process in the January 16th and February 20th, 2023 public hearing notices from both the City of Marshall and Marshall Township. Marshall Township Board meeting minutes clearly show that Trustee Lyng voted yes on the Public Act 425 land transfers on January 26th and February 20th, 2023. You now have all of the evidence that this petition language is stated factually and clearly. Thank you.
And Mr. Lyng is present. Mr. Lyng, do you or a representative wish to comment on the recall petition?
Yes, Your Honor. Good afternoon. My name is Chris Trebilcock with the law firm of Clark Hill, here on behalf of Trustee Lyng. No matter how many times Mr. Kowalske says clearly or clear, doesn't make it so. As we submitted in our response to the petition on Friday, there are a number of issues with the language used in the recall petition that fail to meet the statutory standard. Now, as much as Mr. Kowalske wishes to tie the two statements together, when you read these objectively and limited to the four corners of the paper, a fair reading, and I think the actual reading, is that there's two reasons, and that an elector reading it would suggest that there's two reasons there. There is the first sentence that says Trustee Lyng was serving as a township trustee while also serving on these other boards. That in and of itself is a reason that could be used as a reason for recall. However, where it fails is it does not provide any indication of when those positions were being held by Trustee Lyng at any point in that sentence. The statute requires you to look at each reason. The statute is very clear. You can list multiple reasons in a recall petition. And if you don't sufficiently tie the statements together, as in this case, that renders the language unclear as to what is the course of conduct being referenced in the petition. So one way you could read this is, and I think the correct read is, you've got two reasons. One is he was holding these multiple positions, and then the second reason listed is that in one of those three positions, he voted for these land transfers. Mr. Kowalske, as a matter of fact, made that point very clear when he said, look, only as a trustee could he vote for these land transfers. So why include these other references but for that it's an independent reason, the first reason for recall? There are two issues there. He's got one issue being holding these multiple offices, and the second reason being the vote for these land transfers. And so, as drafted, it lacks sufficient clarity so that an elector knows the conduct or the course of conduct giving rise to the recall. For that very reason, it should be rejected. And again, that first reason isn't timed, doesn't reference a period of time or at what point in time Trustee Lyng held those positions. So therefore, it lacks sufficient clarity. Second, and as we detailed in there, it is unclear in terms of what the suggestion is as it relates to the first one, or if you even try to tie them together, it lacks sufficient clarity. I would also point out in the second transfer, land transfer, this is different than the first one that we looked at where we said didn't reference land transfer and that's a technical legal term. I still say that's a technical legal term, but the additional problem that adding land transfer and the dates, which was another reason last time it was rejected because there was no dates included, is that now we have two dates in reference combined land transfers. Well, actually, there were different land transfers. So one course of conduct was the land transfer on the one date, and the second conduct was the land transfer on another date, which involved different land transfers. And so it's unclear for an elector, is the reason both of them together? Is it one versus the other? You don't know, and it lacks sufficient clarity. I think when you take these things at a whole and you read the language as stated, that it lacks sufficient clarity. Now, you and I could sit here and wordsmith a little bit with a few minor tweaks and probably meet the statutory standard. But that isn't this commission's role or my role, is not to point out exactly what could be done different to change it. Rather, it's the proponent's burden to put it in a way that is factual and sufficient clarity. And again, sufficient clarity. It's not just, yeah, I think it's clear. It has to be an objective standard of sufficiently clear. And that was changed by the Michigan legislature back in 2012 to raise that burden of sufficient clarity. Yep.
15 more seconds, sir.
Thank you. I was just about to wrap up and just said thank you. And if you have any questions, I'm happy to answer them.
All right, thank you very much.
Thanks.
Were you timing it too? Very good. All right. All right. I would remind the commission members that the purpose of this meeting to determine whether each reason for the recall stated in the petitions is factual and of sufficient clarity to enable the office holder whose recall is sought and the electors to identify the course of conduct that is the basis of the recall. That is the purpose of this meeting. The hearing is not for the purpose of debating the merits of the allegations. And again, the commission does not have the authority to rule on the reasons for recall, but only as to the clarity and factual nature of the recall language, which is subject to the commission's review. I will now call for a motion on the clarity and factual nature on this recall petition.
Your Honor, I move the commission vote. I move the commission vote on the petition language submitted for recall of the Marshall Township trustee, Robert Lyng, to determine if each reason is factual and of sufficient clarity to enable officer holder Robert Lyng and the electors of Marshall Township to identify the course of conduct that is the basis for the recall.
Is there a second to that?
I'll second that.
All right, that has been moved and seconded, and so I would ask if there's any discussion. I'm going to lead off the discussion because I have some. So, as I said in the beginning, I was not here at the earlier hearing that was based on the submission from Mr. Kowalske that was rejected by the commission as it was constituted. I have reviewed that language that was submitted, and I would indicate so that everyone knows, if I were here on that earlier date, I would have voted to find that the language was not sufficient and didn't meet the statute. This time, I'm making a different sort of determination, and this time I'm here and make this as part of the commission. I do find that the petition language is sufficient, in my view anyways, to give the office holder reasonable notice of the allegations against him. And I recognize the argument that counsel is making, Mr. Treblecock, because it's a very attorney-specific type of argument that I see every day in court with pleadings, and it's based on training that good attorneys have, which is when there are petitions that are filed with the court, they're done sentence by sentence, and each sentence in and of itself is its own allegation. And so it makes some sense to me that Mr. Treblecock would be making this argument that each sentence on its own constitutes an individual specific reason for recall. But I think it's important for me to be consistent with how I've ruled on these in the past as a commissioner, and that is, I think you have to look at the language as a whole to determine whether there are multiple reasons that are listed or whether it is one reason that has multiple sentences in it. The statute talks about each reason, not each sentence. And so I look at that first sentence in this case as being a description, if you will. Whether it's right or wrong is not an issue because it is a factual statement. Whether it's correct or not is not for us to decide, but it is a factual statement about positions that Mr. Lyng has had or has, and when that's read in conjunction with the second sentence, it talks about actions that he took during this current term of office that the petitioner finds objectionable. Again, rightly or wrongly, that's Mr. Kowalski's position here. And the case law, as I understand it, is very broad and very inclusive about allowing this political process to go through. And I think that if this language as presented, which I think does correct the earlier petition because it does include dates and makes it clear that this was during conduct or conduct alleged to have occurred during his current term of office, and does talk about this being transfers of land. I think that that does give enough clarity to a person who might be asked to sign the petition or a person who might be asked to vote in an election, in a recall election, because not only, if it reaches that point, not only is the office holder dealing with the recall language, but he also has an opportunity to present his own language, which is his reasons why he should remain in office, why the recall petition should not be acted upon by the voters. So he has that opportunity. So this, I think, is sufficient. I do agree with what Mr. Treblecock said, that if we were to parse it out sentence by sentence, then I think that there would be a problem with that first sentence. But I don't think that that's how this is meant to be read. And I went back and I looked at my notes, and I think we had a school board member recently who that same type of argument was made, and I gave my same thoughts about it. Rightly or wrongly, that's how I view the obligation of the commission when we deal with the statute and the case law. But it is sufficient, in my view, to give Mr. Lyng an opportunity to respond, and there's nothing about this that is opinion-based, which is typically, when we see issues with these recall petitions, I would say 90% of the time that the problem that comes to play is it's opinion-based as opposed to fact-based. That isn't an issue here. So it's really a clarity issue, and I think that there's sufficient clarity. So I will be voting to approve this language. Any other discussion?
I just wanted to, again, thank everybody that's sent things in. Each time I sit on this commission to look at recalls, I learn something new every time. Do I always agree with some of the things? Not always. But again, that's not what we're here for. We're not here to debate whether or not this should go through or not. All we got to look at is factual and clarity, and that's what I voted on the first time. And I felt at that time that it was clear and factual. Two of the other members disagreed with me. That's why we have three people on it, to make sure that we have everybody's comments and we get to listen to both parties, and that I appreciate. And again, every time I sit on this, I learn something new, and I want to thank both parties for bringing a lot of this information, because the sad part is, Judge has mentioned, we're seeing more and more of these recalls coming up, and it's harder and harder to sit here and say, yeah, I agree or disagree. But thank you very much.
So yes, the last language, we did feel that, or 2 out of the 3 of us did feel it lacked some sufficient clarity. And for myself, I do feel that this time it does fill that gap that I needed to have filled for me to be able to approve or reject the language. And a lot of times when we reject language, they come back with a whole new pot of fun for us to decipher through. And so this one, I think, listened to our comments, and Mr. Kowalske acted on what our comments were from the last one. I do also understand where Mr. Treblecock was coming from, and concur with the judge that if you were going to piecemeal it, I can understand that, but we need to look at the 4 corners of the language. And so therefore, I have my vote ready to go as well.
All right, I would ask that the clerk, the election specialist, Ms. Stout, take a roll call vote.
A motion is on the table requiring a vote of the clarity and factual nature of the petition language submitted for the recall of Marshall Township trustee Robert Lyng. Commissioners are asked to approve or reject. Clerk Hinckley.
Approve.
Treasurer Wensauer.
Approve.
Judge Jaconet.
Approve.
By a vote of 3 to approve versus 0 to reject, the petition language is accepted.
All right, thank you. Now, the commission members will sign a notice of determination for the recall language that's been submitted. The notice of determination will be available following this meeting and will be sent to all parties. And I'm going to advise Mr. Lyng and his counsel that the determination made by the board here today may be appealed to the Calhoun County Circuit Court in Battle Creek within 10 days. So that would be by the end of business on April 21st, 2023. I would advise Mr. Kowalske that it is recommended that the circulation of petitions should not begin until the 10-day appeal period has elapsed. Signatures collected during the 10-day appeal period may not count if the decision is appealed. The petition language is valid for 180 days following the Board of Election Commissioners determination today, or a determination by the Circuit Court, or 40 days after the date of an appeal being filed, whichever occurs later. It is important to review Michigan election recall law sections 168.951 through 977 before circulating petitions. Specifically, the petition must be in the form prescribed by the Secretary of State. The language must be identical to the language approved today. The circulator of the petition must be 18 years of age or older and a U.S. citizen. The circulator does not need to be a registered voter. Each person signing the petition must be in the circulator's presence and be qualified registered electors of Marshall Township as listed in the heading. The notice of determination will be circulated, but I will indicate at this time that there's a spot on the agenda for citizen or public comments that are limited to 3 minutes each, and I would ask if anyone has any comments to make. And again, I'd ask if anyone has any comments to make. And one final time I'll ask, apparently not. So election commissioners' comments, and I do have some final comments, and I have very close friends who are on both sides of this issue. And I know that this is an issue that has created a lot of fervor and attention, and feelings are strong. And whatever comes of this recall petition, whether there are enough signatures that are received in order to get the petition on the ballot, and if so, whatever the outcome of that is, I don't think that that's going to do anything to quell the emotion that surrounds this issue. But the close friends that I have that are on both sides of this issue, all of them are reasonable people that have differences of opinion. And so this falls into that category where it is something that's contentious and reasonable people can disagree about it. My own feelings about this issue are immaterial, and they don't enter into how I vote in this type of clarity hearing, not at all. And that's fortunate, because it confines my role and the role of our other commissioners to be really specific and look at the language and make our determinations And everyone should understand that that is not an endorsement of Mr. Kowalski's position or a referendum on what the commissioners think about Mr. Lyng, or vice versa if we had gone the other way. It just is a confined determination. And I think that's important to say for this type of issue that's so contentious in the community. So those are my comments. Any other comments? All right. And then the next item on the agenda are announcements, and I don't have any. Ms. Stout, are there any announcements that you have? Commissioners? Mr. Dyer? All right. Then I would ask for a motion to adjourn.
I'll make that motion that we adjourn this recall.
Second.
All right. And I will adjourn this hearing. Thank you very much.
Talk to the girls.
All right. Yep.
Thank you. I was supposed
Jerry, talk to Glenn on that.
He's busy.
Please stay here.
Just a minute.
Jerry Bosser.